Welcome to this explainer. Today, we're going to demystify the complex and honestly sometimes incredibly high stakes legal frameworks that govern private security professionals. If you've ever wondered where the exact line is drawn between just observing a situation and actually taking legal action, well, you are absolutely in the right place. We are going to break this whole thing down, step by step.
To make sure we're operating with absolute precision today, we are grounding this explainer in the official standards set by the Oregon Department of Public Safety Standards and Training, or DPS-ST. These are strict, state-mandated guidelines. So, whether you're actively working in the field right now or you're just kind of fascinated by the legal boundaries of protecting property, this is going to give you the exact framework you need. Okay, here's our roadmap for today. We've got 5 steps. 1. The baseline of certification. 2. The limits of authority. 3. Civil torts and liability. 4. Navigating citizens' arrests. And finally, 5. Criminal law and evidence. Let's kick things off with a crucial hook. We really need to bust that classic rent-a-cop myth right now. So, do private security professionals actually have the same legal powers as a sworn police officer? It's a super common misconception, and let me tell you, getting the answer wrong here can lead to some serious legal peril. Section 1, the baseline of certification. Minimum standards. Before you can exercise any authority whatsoever, you got to meet these baseline minimum standards. You need to be at least 18, possess a high school diploma or its equivalent, and successfully complete some pretty rigorous training and exams. But perhaps most importantly, you have to meet strict moral fitness standards by passing a thorough criminal background check. This is absolutely crucial because it ensures only those with the proper maturity, education, and moral character are actually allowed to wear the uniform. Moving on to Section 2, the limits of authority, you versus law enforcement. Okay, so here is the reality check. A private security professional generally has literally no more legal authority than any other private citizen. You're not a police officer. You only possess the exact same authority as an average citizen, plus whatever specific, limited authority a property owner delegates to you while you're protecting their premises. You cannot engage in conduct restricted by law. Period. Section 3, Civil Torts and Liability, the peril. Let's look at the stark contrast between civil and criminal law. Think of it this way. Civil law is essentially a dispute between private parties. If you wrongly injure someone or violate their rights, it's going to cost you money in damages. Criminal law, on the other hand, deals with wrongs against society as a whole, which brings down government punishment like fines or even jail time. If you don't fully understand the law out in the field, you are incredibly vulnerable to civil lawsuits. In civil law, a private wrong is called a tort. If someone sues you for a tort, it's like a 3-step domino effect they have to prove in court. First, that you had a legal duty to them. Second, that you breached that duty. And third, that they were injured or damaged as a direct result. Let's dive into some specific torts you might accidentally commit if you aren't super careful. The most common tort is negligence. This basically means failing to exercise reasonable care toward others. Imagine you're driving a security patrol vehicle. You get distracted for just a second, and boom, you crash into someone. That failure to act like a reasonable, prudent person, that's a breach of duty. It is a textbook example of negligence. Next up is an intentional tort, assault. Now, in civil law, assault doesn't necessarily mean you physically hit someone. Actually, it occurs when you intentionally cause someone to reasonably fear immediate harmful contact. So if you lose your temper and aggressively threaten a trespasser to the point where they truly fear a physical strike is coming, well, you may have just committed civil assault. The crucial distinction to understand here is escalation. The moment that physical threat turns into actual physical contact, like, say, an aggressive shove, it escalates from assault right into the tort of battery. Battery involves the actual offensive or harmful physical contact. Our last major tort is false imprisonment. This means forcibly confining someone's freedom of movement without strict legal justification. Imagine you suspect someone of shoplifting. You take them into a back room and you block the door so they can't leave. Unless you have absolutely perfect legal justification for doing that, you are risking a massive lawsuit for false imprisonment. Section 4, Navigating Citizens' Arrests, High-Stakes Action. To avoid that false imprisonment charge, we have to look at Oregon Revised Statute 133.225. This is your rule book. Unlike police officers who can arrest based on witness statements, this statute dictates that you, as a private person, can only make an arrest if two specific things are true. The crime happens right in front of your own eyes, and you have probable cause. You cannot play detective and try to piece it all together after the fact. But what if you actually have to use force to make that legal arrest? The law is incredibly strict here too. You are only justified in using physical force to the extent you reasonably believe it is absolutely necessary. And remember this golden rule. As a private citizen, you have zero legal duty to take action. You always have the right to retreat safely. Your life is worth so much more than property. So here is where we draw a hard line in the sand. You may not detain another citizen under any circumstances unless a full, lawful citizen's arrest has been made. Simply holding someone against their will to wait for the police just because they, say, refuse to let you search their bag, that's illegal. Unless all the elements of a citizen's arrest are completely met, you literally have to let them walk away. Section 5. Criminal Law and Evidence. The aftermath. When you're reporting a crime to the police, your terminology matters immensely. You really have to distinguish between a dangerous weapon, which is any object used in a way that could cause serious injury, like a heavy rock, and a deadly weapon, which is an item specifically designed to kill, like a firearm or a combat knife. Accurate reporting is what keeps responding officers safe. Once the immediate danger has passed, your focus has to shift entirely to evidence. Identify it, sure, but absolutely do not touch it. You want to secure the area by cordoning it off, note exactly who enters and leaves the scene, and then just wait for law enforcement. Your role isn't to investigate. It's to maintain a pristine chain of custody by ensuring nothing is tampered with before the police arrive. As we wrap up this explainer today, I want to leave you with one final critical question to think about. Where do you draw the line between observing and reporting versus taking direct, legally risky action? Understanding the strict boundaries of civil liability, the precise requirements for a citizen's arrest, and the absolute limits of your authority is exactly how you balance your own personal safety against the incredible responsibility of protecting property and people. Keep this legal framework in mind out there, stay safe, and thanks so much for learning with us today.